Be seated. Good morning. Now is the time set for oral argument in cause number 1 CA IC130057 Banner Health versus Stauffer. For your information, counsel, these proceedings are being both video and audio recorded, so barring any unforeseen problems with that system, you can go up and critique your performance on YouTube in a couple of weeks. Counsel, each side will be entitled to 20 minutes, and we would ask that you respect that time period. The timer located on the podium will let you know how much time you have left. An appellant, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all your time. However, ultimately, your reserving of rebuttal time will be up to you. We have reviewed the briefs. We have conferenced the case, so we are well aware of the facts and issues attendant to this argument, and you might want to calculate that into your use of time in the course of addressing the court this morning. When you come to the podium, I would ask that you each state your name, who you represent, and with that, appellant, you may begin.
Thank you. I'd like to save 3 minutes in rebuttal. My name is Steve Baker, and I represent Banner Health in this matter. Let me start off by defining what a compensable loss is. And for this, I rely upon Yates versus Industrial Commission, 116 Arizona 125, Court Act 1977. A compensable loss is a change in condition with some loss. Lost time from work, medical expenses. And then let me say that a compensable loss is not a prerequisite to filing a claim. An individual may file a claim upon the belief that they have a compensable loss, subject to the requirement that they be able to prove it at the time of hearing. I'm sure Mr. Kavanaugh and I have both had cases where a claim has been filed, and at the time the claim was filed, there was no expert to support your claim. In those cases, you can ask the judge for a continuance if you protest the denial of your claim, as you look for an expert. If ultimately you can't find an expert to support your claim at the time of hearing, you lose. So in this case, let us just suppose she files her claim, which she did. It's denied, which it was, and she searches for an expert. And within the 90 days, she can't find an expert to support her proposition that she has a compensable claim. She loses, it becomes final, claim preclusion applies, and she's barred from filing any further claims arising from that injury. So there's nothing unusual about the scenario in this case, even if you accept everything she says is true, that she couldn't find an expert to support her claim by the time the 90 days ran.
Well, is it that she couldn't find an expert to support her claim, or that she couldn't find a doctor that could tell her what was wrong?
Well, either way, you don't have to have a doctor to tell you what's wrong, either to file a claim. There's nothing in the rules that say you have to have a doctor at the time you file a claim to support your proposition. You don't have a doctor at the time you file your request for hearing. Nothing in the rules say you have to. You do have to meet your burden of proof when you get to the hearing. Now, Mr. Kavanaugh and I both have cases in which we have doctors with multiple diagnoses. Starts off as a median nerve entrapment, then we think it's an ulnar nerve, then we think it's the shoulder, then we think it's the neck. We've all had cases where the doctors aren't sure of exactly what the condition is at issue. So what happens is the individual says, I've now got these symptoms. I never had these symptoms before. The doctor says, well, one of these symptoms is more likely than not related to this injury. Therefore, if I go to hearing, I can win with that. I don't have to have a definitive diagnosis in order to prevail. I don't have to have a definitive diagnosis in order to file a claim. I don't have to have a definitive diagnosis in order to file a request for hearing. So, in this case, the applicant admittedly did not timely file a request for hearing, protesting the notice of claim status, denying her claim. So unless she can find an exception pursuant to AR Section 23-947A, claim preclusion applies. And 23-947 is a claim preclusion statute pursuant to the Circle K case I cited. So If she doesn't meet the exception for 23947A, then she can't later on file a claim, which is what she attempted to do in this case. She didn't timely file a request for hearing. The notice became final, so then she tried to split her claim by filing another claim. You can't do that because 23947A is a claim preclusion statute, not an issue preclusion statute. In this case, the applicant argued that she relied upon a representation from the claims adjuster in not filing a claim. So let's analyze that. What was the representation she relied upon? The representation was, you don't meet the criteria for a hernia statute. She filed a claim for a hernia and rectal bleeding. But even that's a misnomer. When you file a claim for all conditions, whether known or unknown, which is why we have the reopening statute. But a prerequisite to reopening is an accepted claim. 23-1061 specifically says that in order to reopen a claim, there has to be an accepted claim. There was no accepted claim in this case, therefore she would be barred from reopening, and unless she meets an exception under 23947A, she would be barred from ever filing a claim again related to this injury if she didn't timely protest the notice of claim status denying the claim.
So is it that the initial claim was a non-compensable claim, or is it that she didn't protest the denial of it timely?
She didn't protest the denial of it timely. She did not meet the criteria for a hernia. The adjuster denied the claim. If you believe her testimony, she had a compensable claim from the ruptured hemorrhoids. Remember, her testimony is that she went to the ER and a healthcare provider there, a PA, told her these ruptured hemorrhoids are from lifting the patient. However, when you looked at the medical records, which both parties submitted into evidence, the medical records didn't support that proposition. There wasn't anything in the records that said she had ruptured hemorrhoids from lifting a patient. So if the claims adjuster had come to me and said, Steve, I've got this case where there's a claim for ruptured hemorrhoids, the injured worker is saying that the PA told her they were related, the records don't support it, what should I do? I would have told the adjuster, I think there's a good faith basis for denying the claim. If she protests it, let's move forward with an IME, with an internist, to see if there's a basis for her contention that these hemorrhoids are work-related.
So this took some 7 months from March, I want to say March 13th until something like September 20th, before the issue was fully known and corrected.
Well,
and she could have strung that out for 7 months on an appeal of the denial while they were still trying to search around to figure out what it was that was wrong with her?
Well, we know one thing was wrong with her for sure, based upon her testimony, and that was the hemorrhoids. If you accept her testimony, she had a compensable claim for the hemorrhoids that she could have proven at the initial hearing. So let's say that she'd gone to hearing and she had proven that the hemorrhoids were work-related, she'd gotten treated, closed without impairment. 7 months later from that date, let's string it out even further, she finds out, wow, you know, this groin pain, even though my hemorrhoids have been treated, has never gone away. She goes to the doctor. Well, it looks like there's also a hip problem going on here. It's related to the injury. She could file a petition to reopen and have that covered. That's the exception to res judicata that we use in workers' comp, as long as you meet the criteria for 23947A. As long as there's a claim that's been accepted, you can reopen until you die for conditions that are related to the injury that were not known at the time of the injury. So it's her contention she relied upon a representation from the adjuster. Well, the adjuster told her what she knew. You don't have a hernia because there's no descent of a hernia, and ultimately you don't have a hernia. So the denial was appropriate. It was then her burden to file a request for hearing. The fact that she's continuing to get medical care and working it up is irrelevant. She doesn't have to have a definitive diagnosis to pursue her claim. That's why we have reopening. All she has to show is that she's got a condition she didn't have before. It's probably related to work. You don't need a definitive diagnosis. So the judge specifically found in his decision that a healthcare provider told her she had hemorrhoids that had ruptured as a result of lifting the patient. And yet he goes on to say that she relied upon the representation that she didn't have a hernia and not requesting a hearing. Well, that doesn't make sense. She had a compensable claim if you understand her reasoning or accept her reasoning, and yet she didn't file a request for hearing. The denial became final. Claim preclusion applies. She can't file for that same claim with later with a later claim. We had the situation pretty analogous in Gerhardt. Gerhardt was overruled in the new version of AR Section 23-1061, such that you can't reopen a denied claim. And there was a loss for the applicant in regard to that rectal bleeding because she had a colonoscopy. And she lost time from work as a result of the colonoscopy and the injury. So she had a compensable claim. It was denied, and that's why we have hearings, so we can figure out which side of the story is correct. Are these hemorrhoids or are these hemorrhoids not related?
Well, the colonoscopy was negative, correct?
No, it was positive for rectal bleeding.
But not for the hemorrhoids, which is what they went in looking for, correct?
No, that she had the hemorrhoids. That was confirmed, and they were confirmed that it was bleeding. So the theory that she had at the time she didn't file a request for hearing was, I've got hemorrhoids that are bleeding. I've been told by the PA that the bleeding is as a result of lifting the patient. And so when she failed to file her request for hearing, and if you believe her version of the facts, she had a compensable claim. She'd lost time from work, and she'd incurred medical expenses in the form of the colonoscopy and the workup by the GI doctor. Applicant argues that the rectal bleeding was moot because it had stopped, but that doesn't matter. She still had a compensable claim if you believe her version of the facts. So the judge found that there was justifiable reliance, but what was there justifiable reliance upon? Well, she relied upon the carrier's representation or the employer's representation she didn't have a hernia. That was correct. And yet she still didn't pursue her claim, even though she knew she had a claim for, at the very least, rectal bleeding. Additionally, she's being worked up for a number of different conditions: an ilioinguinal nerve entrapment, a labral tear of the hip. And I would submit that if the doctors had come in from the Core Institute and had said, she's either got an ilioinguinal nerve injury, or she's got a labral tear, or some other pathology related to the hip, the workup is as a result of the industrial injury, that's enough to win. That meets your burden of proof as long as the doctor says the workup is probably related to the industrial injury. So when you boil this case down, she suffered a compensable injury as accepting her version of the facts. It was denied, and she didn't file a request for hearing. She did not have to have a definitive diagnosis to file a request for hearing. An example I can give: individual believed he had developed lupus as a result of exposure to solvents at work. He files a claim. He does a letter to the judge. I'm looking for an expert to support my claim. Can I have some extra time? The judge grants it. By the time we get to the hearing, he still doesn't have an expert. He loses. That's not that uncommon at the Industrial Commission. You don't have to have proof of your claim in order to prevail at the hearing level when you file the claim or file the request for hearing. I think the judge, who's a very good judge, mixed up two ideas here. You do have 1 year within which to file your claim for when you knew or reasonably should have known of the injury. But if you file a claim, then you've got only 90 days to protest the denial. Those are two different concepts. It's not that much different than Superior Court. I've got 2 years to file my claim or file my complaint. I have an auto accident on day 1. I file my complaint and serve it within 60 days of the accident. At that point in time, I've filed it prematurely because I don't have all the experts I need to show that my injuries are related to the car accident. Well, if I lose that claim because the other side moves for summary judgment and I don't have an expert, or I don't prosecute it diligently and I get a dismissal with prejudice because of failure to prosecute, I can't then, within the statute of limitations period, file the complaint for the exact same accident. It's barred by claim preclusion. That's what we have here. She filed a claim, knew she'd been injured, was working it up, claim was denied, and for whatever reason, she didn't file a request for hearing within the 90 days. For all intents and purposes, using Superior Court language, the claim is therefore dismissed with prejudice because 23947A is a claim preclusion statute. So she can't refile it even if she files it within 1 year. No different, hopefully I'm stating Superior Court rules correctly, than Superior Court. And one of the things that she said at hearing that I thought was important was that, and I hope I'm quoting her correctly, she didn't request the medical records from the physicians at the Core Institute, which indicated that they were working her up for various hip conditions, and that would have given her a prima facie case for a hip injury related to her industrial injury, nor did she ask the doctors at the Core Institute if whatever condition they were working her up for was related to work. If we apply the justifiable reliance, she's got to do an independent inquiry. And while she was working herself up for various conditions, the key thing she wasn't asking is this work related? And if she had asked this based upon the records that I've submitted into evidence, the doctors would have told her, we can't say exactly what you have right yet, but given the fact you didn't have these symptoms before and you have them now, whatever it is you have is probably work related. And that's more than sufficient to win at hearing. So, in summary, she filed a claim, made an application for all benefits. It was denied. There was a reasonable basis for denying the claim. She failed to file a request for hearing. Claim preclusion applies. She can neither petition to reopen that same injury, nor she can file a new claim for a different injury arising from the same set of circumstances. Unless you all have any questions, I'm going to reserve the rest of the time.
Thank you, counsel.
Good morning. I'm Dennis Kavanaugh, and I represent the respondent, employee Adrian Stouffer, this morning. Your Honors, I suspect this is not the usual compensability case that comes before you from the Industrial Commission. At the time this matter went to hearing before Judge Sheo, both parties were basically in agreement that Ms. Stouffer had suffered some type of work-related injury on March 13th of 2012. Physicians for both parties agreed on the diagnosis of what that injury was and the treatment for that condition. However, we're here due to the question of really two things: justifiable reliance as an excuse for a late request for hearing. Admittedly, my client filed a request for hearing more than 90 days after the initial denial was issued. And the question is, did she do enough? Judge Sheo certainly found the applicant to be credible based on her search, her journey in terms of trying to find out what was wrong with her. She did this search over a 6 to 7 month period of time following the claim denial, and the records are quite an odyssey of opinions from doctors. It was almost a new diagnosis of the week, and the next doctor saying, yes, I'm willing to do a procedure. We'll try to figure out what is going wrong here. But in none of those instances, through none of those diagnostic studies or procedures, did anything arise that the doctors advised Ms. Stouffer that she had a work-related injury directed back to the accident on March 13th of 2012.
What about Mr. Baker's argument that she didn't need a definitive diagnosis to pursue her claim? She believed that she had hemorrhoids and rectal bleeding as a result of the work-related incident, and that was sufficient to move forward.
Well, Your Honor, as you note from the record, the rectal bleeding stopped within 2 weeks. The applicant testified that she thought that condition was moot. Her greater issue was the ongoing abdominal pain, and that's what she was searching to try to find a diagnosis for. She was advised it was a hernia. Then she was advised it's ovarian cysts. Then she was advised it was condition A, B, C, D. Even the doctors at the Core Institute never told her that it was a hip-related condition. She had a pelvic MRI done, which Dr. Feldman characterized the findings as unremarkable.
But is it sufficient that she believed she had a work-related injury from that incident and that the fine-tuning of exactly what it was didn't forestall her moving forward, or didn't prevent her from moving forward with her claim?
Well, certainly I would concede that there are some applicants who file claims on that belief, but you have to have more than that to really pursue the claim. Just because, I hurt now, and I didn't hurt before March 13th of 2012, without having a diagnosis, that won't get you very far before the Industrial Commission. You can file a claim for that, but that doesn't meet the requirements to establish the claim. And even as she'd done that, again, through a long litany of evaluations and tests and studies, I don't think she would have discovered what was going wrong with her by the time the matter had proceeded to hearing before the Industrial Commission.
But she could have waited to file the claim then.
Certainly, you have 1 year to file a claim. It's rare for applicants to do that. When you have the medical bills piling up, you file the reports with your employer, and typically the claim is filed through the doctor's office directly to the Industrial Commission, and that was the case here. Mr. Baker raises an interesting question in terms of what is the standard, what should be the standard for reasonable diligence. Even if it imposed a burden of requiring the applicant to request and read every medical report from the date of injury to the date the denial notice became final, in this case, there would have been nothing to support a claim. There would have been nothing to support a hip injury. Because again, remember, the findings of the April 13, 2012 pelvic MRI were characterized by Dr. Feldman as unremarkable. So the medical evidence during that 90-day period, even if she had requested the records, and that's not something that is typically done. How many people in this room request medical records after every visit for a doctor that they go to? That doesn't happen in the vast majority of cases. And even if you impose that burden on this applicant because she happened to be a nurse, those records simply wouldn't have helped at that point in time.
So exactly what did she justifiably rely on? Ms. Hayes tells her you don't have a hernia. How is that?
Well, Your Honor, what Ms. Hayes told her is that you don't have a hernia that's covered by statute. Mm-hmm. You may have a different kind of hernia, an idiopathic hernia, which is not covered by Arizona law. So she was told it's a hernia, but it doesn't qualify under Arizona law. That's what was the substance of the telephone conversation between Ms. Hayes. That's really what is expressed in the right to deny letter. That letter clearly is, that's a hernia letter. For anybody who does worker comp, people will understand that. The employer's report of injury also talked about doubting the validity of the claim because it didn't meet the criteria of the hernia statute. And so she was operating based on her communications with Ms. Hayes, as well as the various diagnoses from the doctors, the physician assistants who evaluated her in those initial weeks and months after the injury. And so she really thought that she had a hernia claim that wasn't covered by worker comp. She still had conditions and symptoms that she was trying to get addressed so she could get treatment and get back to work.
Was there ever any question by the time she went through the issues of hernias and hemorrhoids and hysterectomies and all the other things that people kept pointing the finger at different area, by the time you get to the labral tear, is there any question about whether or not that labral tear would have occurred as a result of the incident where the woman fell on her?
No, by the time the surgery was actually done by Dr. Maddox. At least that was the first point in time where the labral tears were specifically identified, and that's where Dr. Maddox advised her. Because of the position of the labral tear, he directly connected it with the injury at work. The IME by the carrier doctor also confirmed that same opinion.
And so I'm clear on this. The first time the first time that there was a connection from the labral tear to the incident in the hospital when she was performing her duties that we know started something off, that until it was discovered and corrected, there was no tying that issue back to the specific incident.
Yes, Your Honor, that was the first point in time where a physician relayed that information to the applicant.
Thank you.
Thank you.
So would you, let me rephrase as I understand the issue here. It seems to me that Banner's argument is she could have requested a hearing to keep this issue in play. And you don't disagree, I mean, and then while she was trying to find someone to diagnose what was causing the problem, and that as long as she found someone by the time the hearing took place that could testify that this is the problem and it's work-related. And so as I see it, and would you agree that she could have done that?
Yes, sir.
Okay. So then the issue is the fact that she could have done that but didn't. Does that preclude her from filing a new claim?
No, it doesn't, Your Honor, because again, the new claim is based on a condition that was diagnosed within 1 year of the incident. She filed the claim within 1 year of the incident, and it was clearly a different diagnosis than anything else that had been posited by any of the other physicians.
But I think the statement is that the claim, the initial claim, isn't based on saying, I have a hernia. It's, I've been injured, whether it's a hernia or something else. And then she has the time, the employee has the time to, is it a hernia? Is it a hip? Is it, you know, I mean, what precluded her? Nothing precluded her, right, practically speaking, from continuing to search and continuing the hearing if she had protested, if she had requested one, continuing it's actually taking place until she could try to find a doctor telling her, yes, this is the problem and this is work-related.
No, you're correct.
Okay,
You're correct.
so why shouldn't this, and you're saying, if I understand your position then, your position is you could have done all that, but the statute doesn't prevent you from filing a new claim within a year, once you've found the doctor.
Once you have found a correct diagnosis relating it to the incident.
Shorthanding it, but
Yeah.
a doctor that says, I found it, and yes, it's work-related.
Exactly.
So those are the two competing statutory provisions.
No, they really are, and it's not necessarily an unusual situation for a worker to file a second claim arising out of an incident on a particular occasion. And again, I think that some deference should be given to the processing of the case by the Industrial Commission. The Claims Department accepted the second claim. It raised no objection. Assigned a new claim number to the second claim. It directed Banner to investigate the claim, to review and accept or deny the claim. This is, I suspect, we haven't seen this in case law in any reported decisions, this particular situation, but I suspect it's because the matter plays itself out before the Industrial Commission. The other interesting alternative basis to support filing a second claim really is the question of the validity, perhaps, of the original denial notice. You recall in our brief we cited to the Roseberry decision. The question, when the denial notice was initially issued, Banner had in its possession medical reports indicating that there were two injuries they were dealing with, a hernia and rectal bleeding. And in this particular situation, the carrier simply denied the claim. In its report of injury, it was certainly attempting to deny a hernia claim, It said nothing about the rectal bleeding. And so it's an interesting question that, with the application of Roseberry, make that April 3rd notice void and permit the filing of a second claim, or would it simply at least eliminate any res judicata effect of that notice?
Am I correct that there's one claim, denied, no request for hearing, second claim, and then at the hearing, the ALJ essentially says the second claim is in essence a delayed protest?
No, Your Honor. The judge said that he did not need to reach an issue on the decision of the second claim
Because?
because he found that the applicant justifiably relied
That's what I mean.
on the first one.
Because,
Yes.
I mean,
Yeah, that's right. He was focusing on that.
90-day deadline based
Right.
on justifiable reliance.
Exactly. So he never reached a decision on
right,
claim
so, I
number
mean,
two.
so when I was trying to pose the hypothetical of there's two different competing statutes, really the ALJ never reached that issue about, gee, I can allow her to file a second claim or file a second notice of claim because he construed her second notice of claim in essence as a late filing of the protest. There wasn't actually a protest filed of the denial of claim, right?
No, yes, there was. We filed a request for hearing on that by March 26th.
Well, I mean, on the first claim. In the first claim, no one ever filed a protest
You're-
and said,
You are correct.
right. And then when they deny the second claim, you file a protest.
Yes, sir.
So the court construed the second claim in essence as a delayed filing, because that's what he said. The late filing of a protest, of the denial of her claim, meaning the first claim, because that's the only one that was delayed.
Which is why I made no further findings.
Okay, he's
on
hereby excused.
claim number two.
Okay.
Yes.
All right.
Thank you. So, in summary, on behalf of the respondent, we would urge the court to either affirm the decision of the Industrial Commission below on the basis of the justifiable reliance exception, or upon her ability to file a second claim for a latent injury that became manifest after the first denial date. Thank you.
Thank you, counsel.
The issue as to whether or not you can file a second claim for a denied claim where the denial has become final, I think has been answered by the case law. If you look at the Circle K Corporation case, the court attempted to differentiate between claim preclusion, which bars all future litigation on an injury or an incident, and issue preclusion, which allows you to litigate different issues pertaining to the same incident. It says confusion in the application of preclusion in the workers' compensation cases can be avoided by applying claim preclusion to a claim to reopen or a claim for rearrangement only when a prior claim has become a valid and final judgment through litigation or the application of ARS Section 23-947B, which is the exception to the finality of a denied notice. So what the court, I think, is trying to say is that 23-947 is a statute of claim preclusion, such that if you don't file a request for hearing concerning the denial of your injury and that becomes final, unless one of the exceptions to 23-947 as outlined in 23-947B applies, you can't relitigate any of those issues pertaining to that denied claim. Because here's what you would run into. You would have an applicant who would file a claim for a median nerve entrapment, also knowing at that time that they have an ulnar nerve entrapment, lose on the median nerve, within 1 year file a claim for the elbow injury, within 1 year file a claim for a cervical injury. That would create chaos and would eviscerate 23-947. And every time we as lawyers have tried to weaken 23-947, it's amended to make it stronger. And you see that a lot in the average monthly wage cases I've cited. you can't split claims. You can't split claims in Superior Court, and you can't split claims at the Industrial Commission.
Can I interrupt you? Because we only reach that issue if we find that the ALJ erred by relying on the B2 justification for the late
Correct.
request for hearing. So tell me again, encapsulate your best argument as to why that determination was an error.
Because of the fact that there was no reliance upon the claims adjuster's representations. The claims adjuster said you don't have a compensable claim because you don't meet the criteria for a hernia. That was correct. What was never just addressed with the claims adjuster was, well, what about my other issues? I've got hemorrhoids. They're working me up for a hip condition. That's why we have hearings. That's why she should have filed a request for hearing. There was no justifiable reliance upon the representation that you don't have a hernia. That was true. Where was the justifiable reliance? I mean, what you're really saying is that if I get a notice of claim status in denying my claim, I can fail to file a request for hearing and just go, oh, well, I guess they must be right. She was seeing doctors, and the doctors were telling her, when you look at various medical records, that she had some kind of condition related to her hip. She underwent on 4/19/12 a ilioinguinal nerve block. Physical therapy was ordered, including aquatic therapy, all before this notice became final. The notice didn't become final until July 2nd. And when you look at one of these diagnoses, you know, a diagnosis of pain is enough for a compensable injury. We see cases all the time where the diagnosis is back pain. The person says, I didn't have back pain before lifting. I have back pain now. Therefore, the treatment I'm getting for my back pain is related to the industrial incident. And that's a compensable claim. If
Counsel.
it later turns out you have a herniated disc, you file a petition to reopen.
Thank you. All right. Oral argument is complete. Thank you, counsel, very much. We appreciate your argument today. Argument is concluded. The matter is under advisement at this time, and we will rule in due course. Thank you very much.